Good morning, everyone. Happy Saturday. I am Cindy Reyes, the Financial Education Manager here at EdFed, and I would like to welcome all of you to another EdFed Academy webinar. This one is about estate planning. Just a reminder, our EdFed Academy is our financial education platform where we offer webinars on various topics and efforts to provide financial education and product solutions for our members. Before we begin, please note that all the participants have been muted for the duration of the webinar. We will have some time for Q&A at the end of the presentation, so you can use your Q&A function then. Also, a reminder that this presentation, along with all of our others, have been recorded and are going to be placed on our YouTube channel, which is EdFed TV. We are super excited because we know that estate planning is very important. It's a very important part in planning for the future. We are super excited to have an expert from our business partner, Members Trust, and we hope to provide you all with some helpful information that will help to demystify estate planning and will help you get started. I'm going to go ahead and introduce our speaker today. It's Tamara Pataky Kidd. We're lucky to have her. Tamara brings to Members Trust over 35 years of experience in estate planning and trust administration. She is fully bilingual in English and Spanish, so she can, help us, any members that are Spanish speakers. Prior to joining Members Trust, she served as a Chief Trust Officer for the Southeast of the United States for Merrill Lynch Trust Company and Vice President and Trust Service Manager for Comerica. Tamara earned a BA cum laude from Florida International University and a Juris Doctor from Washington University. She is also a member of the Florida Bar. She is a proud product of the Miami-Dade County Public School System. She was raised in Miami, was a student at Rockaway Elementary and Middle, and attended Coral Park Senior High. Tamara, thank you so much for joining us today. We are so grateful to have you share this valuable information with us and our membership. We've gotten a lot of requests for this topic, and I'm going to go ahead and stop sharing so you can share your screen.
Thanks. Go ahead and share.
Perfect.
Can you see my screen?
Yes, okay. We're good. Perfect.
Okay, perfect. So hello, everybody. Good morning. It is an honor to be here partnering with EdFed. EdFed is one of the credit unions that owns Members Trust Company. And it is truly an honor to just be able to help Miami-Dade County Public School educators because I feel like I have a debt to them, obviously, because I was educated by them. And you guys do a wonderful job with, students. So having said that, let's talk about a will is not the only way. In the words of the very wonderful Maya Angelou, we hope for the best, we plan for the worst, and we hope to be unsurprised by anything that comes in between. And there, my friends, is the essence of what estate planning is all about. So let's talk a little bit about who Members Trust Company is. There's a reason why trust is our middle name. Members Trust Company was founded back in 1987 as a little state charter credit union by a teachers credit union out of Tampa called Suncoast. Very, very similar to EdFed. Our founding CEO saw the need for credit union members across the board to be able to have access to trust services with the principles that credit unions offer services, where the member always comes first. Today, we are a nationally chartered trust company. In 2004, we took this nationally and we became a CUSO, a cooperative of credit unions. And one of our owners is EdFed, and we're also owned by Navy Federal, by state employees, Boeing Credit Union, and many other credit unions across the country. We have Main Street values, but Wall Street expertise, which is really important. And we are industry recognized innovators. What does that mean exactly? It means that we look to find solutions. We are about people helping people, about that credit union movement, right? We have the heart of a credit union. So we look to help our members. So we are OCC chartered, okay? And we are regulated by the OCC, the Office of the Controller of the Currency. And I already explained we're owned by credit unions. We are nationwide in all 50 states and the territories. And we provide investment management and have over $4 billion assets under management. So let's talk about state planning. What exactly is state planning? State planning is just more than saying, I'm going to get a will, okay? It is planning your legacy. It is understanding how you want your affairs handled the day that you're no longer here, and not just the day that you're no longer here, but if in the event that you were to lose cognitive capacity. Because people, folks, they know that we're, as creepy as this sounds, they know that we're all going to die someday, right? However, people don't necessarily plan for incapacity, which is something that could happen to any of us at any point in time. It could be a car accident, it could be an aneurysm, it could be, Alzheimer's, it could be so many other things, okay? We could very much be here physically, but not cognitively, and provisions need to be made for that. It is life planning, it's planning your legacy. So let's talk about what probate is. Probate can be a very bad word, especially Miami-Dade County, where courts are a little bit behind on the probate process, okay? It is time-consuming, it is expensive, it is a public proceeding, and I'm going to tell you a little story. So in the Miami-Dade County Public Schools, I was made to read a book, and it became my favorite book of all time in middle school, and it was by the very famous Harper Lee, and Harper Lee wrote To Kill a Mockingbird. And we all know that Harper Lee was an incredibly private individual. And when she passed away, her attorney filed her will with the courts, and he asked that her will be kept private because they did not, she would not have wanted other people to be in her business and to know who she was leaving money to. And along came the New York Times and basically said to the judge, nope, you cannot do that, because when a will is filed with the courts, it becomes basically a public access event, right? So Harper Lee, eventually we're going to talk about how she got the last laugh from the grave, because she basically had what was called a pour-over will, which we're going to talk about in a minute, and had a trust, and the trust is a private document. But that, in essence, will explain that if you just have a will, all basically the proceedings as to probating that will become public knowledge, okay? You could say, well, I'm no longer going to be here and I don't care, but just to let you guys know. It is court supervised every step of the way. When things are court supervised, that means that they cost money, right? Because you have to pay court fees and attorney's fees. Most of the time, an attorney is needed. And there is a simplified process for small states in the state of Florida, but most states are not going to qualify for that. So who gets what, okay? If you have a will, you decide who gets your assets. If you don't have a will, basically, then you die what's called intestate. And then the state decides who gets your money by statute. So what does that mean? Well, in today's day and age, families might be defined a little bit differently than they have been in the past. And perhaps you have a long-term partner, or or just friends that you consider more family than distant blood relatives out there. And if you don't make provisions within your last will and testament for them, and you pass away without a will, the intestacy proceedings will decide based on statute, which will basically leave the money to your closest blood relatives. So maybe your long lost cousin in Kentucky is going to end up inheriting the money instead of the person that you intended. Not a good thing. So why do you need a will? Because a will lets you determine who will receive your assets. It helps you choose an executor or a personal representative, one of the same. In the state of Florida, it's called a personal representative. It helps you designate a guardian for minor children if you have minor children at the time. So having a guardian name in the will is usually going to be honored by the courts, okay? They are more than likely going to say yes to whatever you provided for, unless, of course, the guardian has some type of cognitive impediment at the time that they need to serve, they are unwilling to serve, or, they've had some type of legal issues. And it also allows you to create a testamentary trust. We're going to talk about a testamentary trust now. That's a little bit different than a revocable trust, which we're also going to discuss at length. Because a testamentary trust does not exist while you're alive. It is established by your last will and testament. It only takes effect, obviously, upon your death. And it gives you the ability through that testamentary trust to control inheritance. I always say it's the hand of the dead controlling from the grave, right? It allows you to say the when, where, and how people are going to receive your assets. You can also include on there spendthrift provisions where you're protecting people from themselves, right? Because if people are not good money managers, and that's why you're leaving the money to them in trust, you are basically saying on there that creditors will not be able to tap into assets inside the trust. So a little bit more about wills. Despite of people's sense of, of what they are entitled to, so people's sense of entitlement, heirs have no interest in your estate until you die. And you, so long as you have cognitive ability, can basically decide to the last second as to who is going to get that money, okay? There will be what's called the separate disposition of tangible personal property inside your will that will be referenced. And this is a separate writing that you write on your, in your own handwriting, you date it and you sign it, and you can leave your most valuable personal assets in there. As an example, if grandma has a 5-carat diamond ring and she has 3 granddaughters, and every time a granddaughter comes and visits her, and then she decides, you know what, I want this granddaughter to have the ring, I want the other granddaughter to have the ring, depending on what mood she's in. Imagine how much it would cost her if she had to go to the attorney every single time to amend her will. So long as she amends the separate writing that is incorporated by reference into the will, and she keeps it up to date, the latest separate disposition of tangible personal property is the one that will take effect. Okay, it needs to be dated and signed, and hopefully in her own handwriting. And then codicils, that's just a fancy word for an amendment to a will. I want to keep in mind that I get wills all the time that have like about 6 or 7 amendments. And sometimes one of those originals gets lost, and that really delays the process of filing everything with the court. In this day and age where, we have access to computers and to so much wonderful technology, it's not going to cost you too much more from doing an amendment to having the attorney redo your entire will. And it will be my suggestion that you keep it to no more than 1 amendment to your will, so that like that, we do not have anything that is missing at the time. Okay, so what assets are distributed by will? Only assets that are in the decedent's name alone, not assets that are joint owner, and no assets where there is a beneficiary designation form. I want to talk about beneficiary designation forms because if I want you to walk away today with anything that is really important here, is the impact of beneficiary designation forms. Most Americans today have 2 major assets, okay? They are, one is their retirement account, and the other one is their home. Any type of retirement account, like an IRA, a 401k, annuities, life insurance policies, all of these different investments are basically governed by a beneficiary designation form. That document, whoever you're leaving your money to in that document, that trumps over any other estate planning document that you might create. So when the best example I can give you is I had a gentleman who in another state, who was an engineer, very successful engineer, had worked for the same company for about 30 years. Unfortunately, he developed pancreatic cancer. And he knew that, pancreatic cancer doesn't really leave you a lot of options for very long. And he had two children that were fairly young. One was about 19 and the other one was about 20. And he wanted to leave money in trust for them. And his largest asset was his retirement account. Think about it. He had been at this company for almost 30 years. So he went through the entire trouble of having a very, very well thought out estate plan done, etc. And guess what he forgot to do with the attorney? Change the beneficiary designation forms to reflect that the trust and the terms that he had placed on that trust were going to be the ultimate beneficiaries of that retirement plan. So the beneficiary designation forms had both his kids on there 50-50, and they were getting the money outright. Now, these were two really good kids. When dad passed away, they approached us and they told us, we want to do whatever dad had intended here. We were able to work through them with that. They set up EREV trusts for themselves to protect themselves with very similar terms for about 10 to 15 years, if I recall correctly. But most kids that age are not going to go do that, okay? And if kids at 19 or 20 come into that kind of money, they're going to be either, waste the money or maybe be taken advantage of in most instances. So it's very, very important that those beneficiary designation forms reflect whatever your estate plan is. So if you walk away with anything here today is bring your beneficiary designation forms to the attorney's office when you execute your documents to make sure they help you fill those out appropriately. All right. And let's talk about will substitutes. I love this slide because I do that on purpose. There is no such thing as a will substitute. Nothing substitutes a will. A living trust or a revocable trust goes hand in hand with a will. What you will have basically is a pour over will, like Harper Lee had, where basically the will is going to say anything that I forgot to put in trust name at the time of my death needs to pour into my trust. Okay. That living trusts are created, and folks, you need to transfer your assets to that living trust, because if you don't, you've wasted your money. So you also need to work with your attorney on making sure that, your real estate, all of your assets are transferred. We're going to talk about that in just a second in more detail. But there is no substitute. The living trust or revocable trust does not substitute that will. Then there's joint ownership. Joint ownership on an account does not substitute a will. It only basically controls that one account. A will is an all-encompassing document. The beneficiary designation forms we just talked about in detail. Just please make sure you pay close attention to those. And then there's transfer on death accounts. And transfer on death accounts are very similar to joint ownership accounts or payable on death accounts, where only the one account is controlled by that provision of transfer on death, okay? Or payable on death. So now let's talk about the revocable living trust. What is a revocable living trust? It's a legal agreement. I mean, this is your own legal agreement that you enter into. You will not go out and buy a house or build a house without an architect, right? Like, you're going to have to get blueprints in order to build that house from the ground up, because otherwise the house will fall on you. Well, I want you to think about your legacy and your estate planning in the same way. It is a blueprint as to your legacy, and you're hiring your attorney to be that architect, right? To basically leave terms on that trust as you choose. It is very, very flexible, and you can include terminology in there, that is very unique to your needs and to the needs of your loved ones. The only thing you cannot include on there is things that are against public policy, like saying, I only leave money to my daughter, Susie, if she divorces her husband, Ryan. That no court is going to uphold that. I'm just letting you know right away because you're trying to end a marriage and that's against public policy. But, you know, lacking a few exceptions, this is your own plan and you can include just about anything in there so long as the attorney finds the appropriate wording to make sure that it is effective. It is privately administered, meaning it is not subject to public knowledge. The trustee administers it and the qualified beneficiaries are the ones that get the statements. So in the case of Harper Lee, she had this pour over provisions in her will that basically said, at the time of my death, anything that I forgot to put in my trust name basically pours into my trust. So guess what? The New York Times was not able to get a hold of her trust. She got the last laugh from the grave. Nobody was able to know exactly who she left her assets to. So who are the parties to a trust? The parties to a trust are you, the grantor. Okay, you are the person or the settler. You're the person creating that trust. Then you'll likely be your own trustee during your life, so long as you have cognitive ability. And you will name a successor trustee in that document. That could be either an individual or it could be members trust company with offices at EdFed credit union, right? To be your corporate successor trustee. And then there is remainder beneficiaries. During your life, you'll be your own trustee over your revocable trust and your own beneficiary. But eventually there will be remainder beneficiaries. That could be family, friends, or charities, whoever you designate. So how does it work to go fund this trust? So we have Jane Doe. Jane Doe creates, you know, the family trust dated 12/30/2024. The trust is revocable. Jane Doe is the grantor and the trustee. And she now is going to listen to what Tamara Kidd said here, and she's going to begin to fund her trust, right? Because otherwise she's wasted her money. So during her life, she works with her attorney to transfer her real estate into the trust, credit union and bank accounts into the trust, investment management accounts, CDs, and safety deposit boxes. Folks, safety deposit boxes are important. You do not want to have a safety deposit box in your individual name and have your last will and testament in there, because I run into the proverbial, what comes before, the chicken or the egg? I cannot begin your probate process in the court unless I have an original will. But the financial institution won't let me into your safety deposit box easily, right? Until I have what's called, until the court has appointed me as your executor or your personal representative, and I have what's called letters testamentary. So either put the safety deposit boxes in the name of your trust so that your successor trustee can immediately access that safety deposit box. Or if you have that safety deposit box in your individual name, do not, unless it's in joint name with someone or somebody will have access to it, do not leave important documents like your will and your trust in that safety deposit box. And a successor trustee basically will be the person that will take over, or the institution that will take over in the case that you become incapacitated or you pass away. So upon your incapacity, and once again, death is going to happen to all of us. Incapacity is a different thing, right? You know, some people will be affected by it, others will not. But with baby boomers aging and, you know, coming into retirement age, we have a large number of people that are going to live a very long time, okay? And the chances of people lacking cognitive ability are becoming greater and greater. So what happens when Members Trust Company takes over? Members Trust Company will take over with offices at EdFed, let's say, as your successor trustee. When you become incapacitated, we gather all of your assets under the umbrella of your trust, and we pay for your mortgage and property taxes. These are some examples. We pay for medical expenses, and we pay for your monthly bills. Okay? That's among some of the things that we do. We take care of all your financial matters. Upon your death, then the trustee steps in and begins to distribute assets according to the trust terms that you left, that you set. Our duty is to follow what you set. So in this case, there's 3 beneficiaries. It is not uncommon for beneficiaries to get money in different ways. You might have child A, who doesn't, who is a very good money manager, has a great job, and you are not concerned that they are going to go through, a horrible divorce anytime soon or anything like that, and you want to leave them the money outright. But then you might have child B, who is a great guy, but is not a good money manager, and also might be facing a divorce or else, and might lose assets. And then you have C, where, you might have a child with special needs, and you need to leave the assets in a special needs trust for that child in order to preserve their government benefits. So it is not unusual for assets to be passed differently by individuals, okay? So what are the benefits of a trust? There are many benefits to a trust. It helps you avoid those probate proceedings that I talked about at the beginning of the presentation. It avoids the need for a conservatorship or guardianship proceedings. Folks, please do proper planning for incapacity, because we are handling guardianships and, conservatorship, guardianship is one of the same. We are handling guardianships, and we do that to service people. However, the cost of that begins to eat up at the money immediately, because there's several attorneys that are involved. Everything has to be court approved. Accountings have to be filed. It is really a shame to see that people could have done proper planning ahead of time, and all of a sudden, everything is inside this guardianship. So please talk to your attorneys, do proper planning. It also reduces, the trust will reduce the likelihood of loved ones to squandering inheritance. And because you're going to basically say the when, where, and how they will get their money. And it can be changed by you at any time, so long as you are alive and you have cognitive ability. Once you pass away or become incapacitated, the trust becomes irrevocable, meaning that it cannot be changed. And that's to protect basically what you left behind, or to protect you while you're incapacitated, to make sure nobody can come and change it. So let's talk about choosing a trustee. These are your options. You can choose a loved one, an institution, or a loved one and an institution. So if you select a loved one as a trustee, these are the things that you need to ask. And I tell people, I'm old enough that I watched that movie with Diane Keaton many years ago. It was called Baby Boom. And in that movie, if you guys recall, she is a top executive in New York. She's not married. She has no children. Her job is her life. And all of a sudden, a distant cousin passes away and leaves her a baby to take care of. But guess what? No one had discussed with her that she was the person that was chosen to take care of this baby. So if you're leaving someone to serve as your successor trustee, as guardian of your kids, or as whatever other role they're going to play, please have that conversation with them. Make sure that they're up to it, that they basically have the emotional wherewithal to take on the responsibility of a trust, okay, and managing it. Are they good at managing money? Does that loved one have the bandwidth in their life to do that and the inclination to take on that responsibility? And is your loved one honest, detail-oriented, fair, and a good communicator? Good communication here is essential. I will tell you that a lot of the business that I get here is parents who left money to that perfect child that I talked about to manage for their sibling who was not so perfect, right? In different aspects. And then that sibling eventually is pulling their hair out and then comes to me and says, you know what? Please take this over. My Thanksgiving gatherings, my holiday gatherings are a nightmare because I get to say the when, where, and how my sibling gets the money. And guess what? It's not working out. It's destroying our relationship. So you got to make sure that that's going to work within your family, because yes, you're no longer here, but you don't want to leave that mess behind. You don't want to leave that burden on your loved ones. So please think about all of that. So you can select an institution such as Members Trust Company with offices at EdFed as the trustee or successor trustee. Here are the advantages of that. We offer professional asset management. We have 7 CFAs on staff. That's the highest designation in the investment arena. We are owned by your credit union, right? And by credit unions. So, you have, if you trust EdFed today, EdFed continues to basically be involved in how your family is going to be serviced, okay? We have legal proficiency to administer the terms of the trust. We are a regulated entity, and I cannot emphasize how important that is, because we are subject to audits and examinations all of the time. And why is that important? Because when an individual is serving, okay, no one is really auditing them. There's no accountings that are placed with the court. You hope that individual is staying honest and that they're doing the right thing. But if they're not doing the right thing, okay, they also do not have capital and insurance to take care of a mistake that they might make or a bad act that they might commit. And then your loved one might be able to send them to jail, right? But they're not going to get their money back. So it is really, really important that you take that into account. It is also a perpetual appointment. And what I mean by that is that if anything were to happen to me tomorrow, I would hope my coworkers will be sad, right? But the next day, there will be somebody else managing the trust within Members Trust Company with offices at EdFed. There will be no interruption in service. When individuals are serving, there tends to be, and people sometimes depend on those trusts to live. So you really don't want interruptions in service. And then you can choose the best of both worlds, where we will serve as co-trustee, where you choose an institution and a loved one, okay? And then it takes the burden off that sibling where, they help us make those decisions. However, they don't have to deliver the bad news. It's that, we are able to basically tell the individual, listen, we decided to not grant this request for X and X reason, and it takes that loved one out of the line of fire. So, and so I talked about us having Main Street values, Wall Street expertise. And that's very, very important, because what credit unions are about is about people helping people, about serving the underserved. We do not require the high minimums that banks require. We are here to help, okay? We can help loved ones with special needs. Special needs trusts are becoming a very prevalent part of society these days, okay? If you go to some of the larger institutions out there, they want $2 to $3 million minimum to serve on a special needs trust, if they're willing to serve, because they're very, very specialized and convoluted type, procedures to handle special needs trust. Members Trust Company, because we're credit union owned, we embrace them, and we have a ton of expertise in handling these, okay? We can also help blended families. 50% of marriages will end up in divorce, unfortunately. Fortunately for some people, I guess. But the point is that, if you remarry, you want to make sure that your second spouse is taken care of. But at the same time, you might want to make sure that your biological children are not disinherited. We can help. We can help blended families. I don't like to call them irresponsible loved ones, but let's say not money savvy, okay, loved ones, okay? Members can restrict trust distributions, reducing the likelihood that those loved ones will squander their inheritance. And Members Trust Company will basically follow the lead of whatever is in that trust to ensure that that is done. With baby boomers, once again, coming of age, we want to have incapacity planning, okay, for your financial needs, because otherwise a judge is going to decide who will take control of your assets. We can help people that have no children or kids that live really far away. So if you're in South Florida, in Miami, and your child lives in Silicon Valley, California, chances are they're not going to be involved in the day-to-day of your, financial affairs, okay? And, it helps unburden your loved ones. It helps takes that, weight off, and hopefully those Thanksgiving gatherings and those holiday gatherings will be better. So our products, we can serve as trustee. We also have a flex IRA where members can control post-death distributions to loved ones. And we also have a great feature with a flex IRA where the member becomes incapacitated. IRAs are one of the few things that cannot be put inside a trust while you're alive because it would lose its tax deferred status. So normally, when an individual passes away, when the individual is alive and they become incapacitated, it would be have to be like a power of attorney or a guardian who would be making decisions over that flex IRA. But we have a feature in our flex IRA where you can allow members trust company to basically step in as a trustee and provide, funds for your health care, maintenance, and support throughout your incapacity from that IRA. We can serve as personal representative. I spoke about that. MTC can help members who die with or without a will by administering and settling the estate through the probate process. We can serve as agent for trustee. And what exactly does that mean? That means that you might not be ready to give up control of your own trust and you want to be your own trustee, but you want to be smart, right? And you want to dip your toe in the water and basically gauge the temperature. You want to know what kind of job members trust company is going to do for you, right? With EdFed, how your bills are going to be paid, et cetera, et cetera. So you can hire us to serve as agent for trustee, invest your funds, and also pay some of your bills. We will act as attorney in fact or power of attorney only of the property. We will never make healthcare decisions over anyone, okay? And the attorney in fact is reserved for people who have a current account with members trust company. And the reason for that is because as in-house counsel for members trust company, I want to ensure we're basically, when you're serving as power of attorney, we are not following, the directives in a trust. We're stepping into your shoes, okay? And we are making decisions for you. I need to get to know you as a client, and I also need to know where all the skeletons are buried. I need to know where all of your money is so that we are able to manage everything accordingly, and that we are able to take care of you while you're incapacitated. And we can also help as conservator or guardian. But once again, I want to avoid having to do that, right? And the whole point today is for you to go out and do proper estate planning. So common questions that I am asked all the time is joint ownership. Does that take care of everything? Let me just put the accounts in my name and the name of one child, and my child is going to go ahead and give the money to their siblings. Bad idea, folks. Please don't do that, okay? Potential pitfalls, unintentional disinheritance. Either that sibling might not end up giving the money to their siblings, or that sibling could die with you in a car accident, and then that money might belong to that sibling's family, and then your other children might be disinherited. So there's also the potential risk of joint owner is sued. They're in a car accident or bad business venture or whatever it is, and if they're sued, people could tap into your joint account. So joint ownership is not the solution. Transfer of death only controls the one account once again, right? So that is not, a comprehensive estate plan. And disinheriting a spouse, this is a really pitiful slide. So if you want to disinherit your spouse in the state of Florida, okay, spouses are still entitled to a 1/3 elective share of your estate. So generally no, unless a prenup is in place, and prenups are not that simple. A prenup has to be done, with all the bells and whistles that it requires, proper representation for both parties, proper notice, proper disclosures, etc. So in the event that you need to disinherit your spouse, please make sure that you consult with an attorney, okay? I talked about powers of attorney, okay? Members Trust Company will serve as power of attorney only for current clients. In the state of Florida, the only kind of power of attorney that there is at this point is durable power of attorney, where basically it begins the moment that you issue that power of attorney to that individual, not upon a triggering event like incapacity. It survives incapacity and it ceases to exist the moment that you stop breathing. Okay, so long as you're in this world physically, even if you're not here cognitively, that power of attorney remains in place. Springing powers of attorney allow you to name someone to take over as your power of attorney and retain control until a triggering event happens. That is no longer allowed in the state of Florida. So springing powers of attorney in the state of Florida, not an option. Okay. Let's talk about tax implications. So today, in 2025, the exemption amount is $13.99 million per person. That means that is the highest amount an individual can pass. That's called the unified credit, free of federal tax in their estate. So, and if you're a couple, it's double that, right? It's 13.99 million per person. So most people do not do estate planning for tax purposes, folks. Most people do estate planning basically to have peace of mind, to know that, that they are going to be taken care of if they become incapacitated, and that their legacy is going to be handled according to their wishes after they pass away, and that they're taking care of their loved ones. I always sometimes like to do seminars where I say that estate planning is not just for the rich and famous. It's for everybody. Everybody needs to consider it. The annual gift tax exclusion in 2025, you can pass on $19,000 per person per year, okay? And that is not subject to a gift tax return. And let's talk about capital gains. So if dad bought a home for $100,000, I don't think there is any such thing in Miami anymore as a home that could be bought for $100,000. But we'll use that example. And then dad passes away, son inherits the home, and the home at appraisal value on date of death is $250,000. Then son sells the home for $300,000. The taxable gain that the son has to pay is only on $50,000. So you get a step up in basis at death, on date of death, to that $250,000, which becomes the benchmark. If you gift the home during your life to your children, there is no step up in basis. So keep that in mind. So I am going to have Cindy provide the information on how to contact Gilbert Cedeno, who is the local representative there at EdFed. Please keep in mind that this adorable slide that they make me show here at the end, this presentation was for educational purposes only. It is not intended as legal or tax advice. And for such specific advice, we ask you to consult with your attorney or CPA. Thank you, Cindy.
Thank
And
you.
let me know if you have Q&A.
Yes, if you can go ahead and stop sharing for a second, and I will share my slide. Okay, perfect. Thank you so much. I think this was incredible. I myself found it very informative. I know for sure everybody in this call, on this session probably feels the same. So I just want to go ahead and thank you for that. I'm going to go ahead and look at the Q&A. Give me 1 second here.
Sure.
So we do have some questions. They started early on in the session, so I'm going to go ahead and read them. So the first one says, if you own a home with your spouse, is it better to change the home ownership to a trust as part of your estate planning? And if you do, can you still have homestead exemption?
So the answer is yes, you can still have homestead exemption, okay? And from a tax planning perspective, I mean, certainly I encourage you to speak with your attorney, but the home being in the trust, yes, it is a very valuable tool.
Thank you. Okay, we have another question. Can a home that is still not paid off be included in an estate trust?
So that depends on your mortgage company. Okay, most mortgage companies will allow for the home to be placed in the name of the trust, subject obviously to, whatever lien is on the home. But you would have to contact your mortgage company individually for that.
Okay, thank you. We do have another one, and it's a scenario that a member provided that says, so we're using the same John Doe is widowed. Let's say he's widowed with several living children, and he is planning to marry his new partner in about 3 months. What if John completes a trust prior to his wedding? And then it says, once he is married, what happens to that trust and all the assets gained prior to marriage? So again, this is before he marries his second partner. And then it says, would you suggest a prenup?
I always suggest for a prenup to be visited, or the idea to be explored before a second marriage, okay? Especially if you are later in life and you're well established and you have children. I think that, of your own, I think that that is definitely something that needs to be at least looked at and consulted with an attorney.
Okay, great. And I have a couple questions here
And,
about.
and I just want to say, I don't want to be held responsible for breaking up any relationships, right? Because I know that sometimes that causes a lot of friction. But it's definitely something to bring to the table and talk about.
Okay. For costs of EdFed being the trustee, again, I will share. If you can see my slide, you can see that it says contact members trust at investmentservices@edfed.org. You can go ahead and reach out to somebody there via that email, and all of that information can be shared with you at that time. I have here again, what are the fees? So again, go ahead and email investmentservices@edfed.org, and we can go through that with you. I do have a question about a ladybird deed. Says, does a ladybird deed avoid taxable gain?
No, no, the Lady Bird deed will not avoid taxable gains, but you do need to, consult with your tax preparer more on gains and tax implications. That
Okay,
is not the purpose anyways of the Lady Bird deed, right?
right. Okay. Question for you. So on that, again, I know I'm getting a few questions about the fees. Do you want to discuss anything about the fees?
Fees as to how much members trust company will charge, basically.
Uh,
I would encourage everybody to reach out to Gilbert, and he can provide you a copy of the fee schedule.
Perfect. Okay. Again, this presentation has been recorded. It's going to be put on our YouTube channel, which is EdFed TV. We do have a few more questions. So I'm going to go ahead and get through them. I just want to do that reminder because we are getting some questions there. What is the best way for a parent to leave a home for an only child?
Okay, so, if you want to leave that and avoid probate, okay, the home, possibly having the home inside a trust and having the child be the beneficiary of that trust.
Okay.
That is definitely one of the ways to explore, right?
Okay. And then again, we have another question, something similar, and it says, can a trust be designated as a beneficiary? It says, to clarify, can a trust be designated as a beneficiary?
Yes, the trust can be designated as the beneficiary, and beneficiary designation forms for IRAs, life insurance policies, annuities, etc.
Yeah. Okay. So I'm getting another ladybird deed question. So it says, if you have a ladybird deed, wouldn't that bypass a will, leaving the home to the person indicated on that ladybird deed?
Normally that would be the intent, right?
Mm-hmm.
If you have a ladybird deed that has been drafted, I would highly encourage you to just consult with your attorney to make sure that it is in sync with your entire estate plan. And furthermore, I would encourage people that have an estate plan or that create one to revisit their estate plan every 2 to 3 years, right? Because as things change in your life, things in your estate plan can change. And things that can change are marriages, death, so many other divorces, so many other things, right?
Yeah, that's a great reminder.
It is a great reminder because I want people to understand that, these things do happen, okay? And people do not change beneficiary designation forms, they forget. And sometimes they leave the former spouse on those beneficiary designation forms, the last thing probably that they wanted to do.
Right.
And then ultimately, they also forgot to change that spouse out of their healthcare powers of attorney or their living wills. And, you just really do not want someone who you're no longer involved with or might have separated from bitterly, as an example, to be the person making your life and death decisions and ultimately be inheriting your
Right.
retirement account or else. That's just one example of why things need to be updated. And if folks think that this stuff doesn't happen, believe me, I have seen it happen over and over again. So
No, you really have shared so many wonderful examples, and I think that covers so many bases that I think that it has brought up these questions. So I do have a few more. I have one that says, can an out of Florida state member of EdFed participate in this service with members' trust?
when you main service, Members Trust Company will not draft the wills for you. Members Trust Company is a trust company where basically we administer trust. We will direct you to attorneys that can help you in the state where you're at. And Members Trust Company can certainly serve as trustee with offices at EdFed in all 50 states, for
Wonderful.
residents of all 50 states.
Okay. We have a few more questions.
Sure.
I am a co-owner of my mom's house. How do I protect myself financially if she passes away to make sure I take full ownership of the home?
It depends how the home is titled, okay? Is the home titled as basically joint tenants with full rights of survivorship? Because then by operation of law, the other 50% will go to the survivor, right?
Mm-hmm.
Or is there a trust involved where mom basically leaves her one half, you
Okay.
know?
Yeah, we are getting a few questions similar to that one. And the other question similar to that one, it says, I own a home with my parents. So here there's both parents, right? Titles in my name and mother's name as joint with right of survivorship. So what happens if my mother passes away? Will my father or siblings have any claim or will it remain mine? Again, this one is titled to both the mother and the one child.
Without seeing the title,
Mm-hmm.
okay? If the title basically says, you know, the child's name and the mother's name as joint tenants with full rights of survivorship, okay? Then when one of those two passes away, the other person gets the entire interest by operation of law.
Okay. So that's that.
But I am not seeing, I mean, I'm
Again,
not
right.
seeing
That's just
the
going off
so
of
I cannot, I'm not providing legal advice there. I'm just telling you how it is supposed to work.
perfect. I know we did talk about safety deposit boxes, and I have a question about that. It says, being that a copy shouldn't be kept in a safety deposit, who retains a copy of the will and any of the other documents?
Well, what I said was that originals should not be kept in the safety deposit box, right? So you could leave them with your attorney, or you could have them in a safe place, like a fireproof box at home, where
Mm-hmm.
somebody knows where it is and they can easily access it in the case of your passing.
Okay. I have a few other ones. They're coming up, a lot of them. I have one that says, I've been with my partner for over 15 years. I have two daughters from a previous marriage. Does my partner have rights to my home, or can I place my two daughters as beneficiaries? And again, you have talked about this. It just depends, I guess, on the title of the home.
It depends how the home is titled, and it depends what provisions you leave on there, on your, on your trust and in your will.
Okay. You have talked about this other question a lot about divorce and your children divorcing. This one says, if your child is now going through a divorce, how do you create something that prevents a future ex from assets?
You can leave them the money that you're going to leave them as inheritance inside a trust, and your attorney can help you draft provisions in there where the spouse will not be able to reach in as a creditor into those assets.
Okay. Oh my goodness, we are getting a lot more questions. So thank you, Tamara, for your patience.
No problem.
I have here a member says, I'm a 65-year-old retired single person with no children. I'm considering a reverse mortgage so that I can travel and enjoy my life more. Plus, I'm barely making ends meet with my pension and Social Security. Is a reverse mortgage a good idea?
I don't really give advice on reverse mortgages. That's beyond the scope of this presentation. But I think that someone probably at EdFed, like, can probably talk to you about those possibilities in their mortgage area and explain that a little
Yes.
bit better.
Yes, I think that's a great answer because it's true. It really does depend on the situation specific.
Right?
Mhm. I do have a lot more questions coming up. Is there a solid prenup in place that specifies what the spouse will get? Will that spouse still be able to petition for 1/3 of your property? So basically getting more than what you wanted them to have. And you did mention about Florida being, them having that access to that 1/3.
There's that 1/3 elective share, but you might have basically contracted that away through a properly drafted prenup. I am not a family law attorney, but you can have basically an ironclad prenup, that where basically the provisions of that prenup is what's going to apply. And that's what I would say to that.
Okay, we have gotten a few questions. I know that we had questions from members asking about ladybird deeds, and there are a few questions of members wanting to know what exactly is a ladybird deed, and then also what's the difference between that and a quit claims deed. If you
Okay,
could,
a quitclaim deed is basically where you are just basically transferring an interest without no guarantees of title, no warrant. It's not a warranty deed, right? You're not warranting the title or anything. You're just transferring the title. Tamara could basically do a quitclaim deed in a property to Cindy, and I'm just giving her the property as is, and I'm not making any warranties on the title. A ladybird deed is more of an estate planning tool that is used basically where you keep an interest in your home and then the home basically distributes out to certain individuals. This presentation is, you know what I mean? It doesn't really encompass ladybird deeds as one of the tools. So once again, I would encourage you to reach out to your attorneys.
yes, 100%. I think just that's a very important reminder that this is just like an information session. But it's important for you to contact your own attorney to get
Yes.
guidance on your own specific situation. We are getting some questions about how early is it to begin planning for your like the retirement and estate planning. This member's 32 years old and is wondering. I think it's never too early to plan, but Tamara, you can definitely guide this.
Start planning and putting money away as far as I see it when you're in high school and you're working part-time.
That's what we tell our students. I think they have a lot less financial responsibilities when younger. And so even though they're not at their highest earning potential at that time, we do
Right?
start recommending that.
Any amount that you put away and the earlier that you start planning, because these days people are living much longer, the better off that you are.
Yes.
Okay, and as far as estate planning, I think that everybody beyond the age of 18 should have a will in place.
Wow, that is wonderful right there for the information, you guys. We do have many, many more questions that are popping up. So again, thank you for your patience. I have here from a member, if you have all of your CDs, bank accounts, IRAs, retirements with beneficiaries, does that automatically leave them the funds also now going into probate? So would that be the first thing? Would that
Okay,
go into
Cindy,
their
repeat me the question. How are the CDs titled and the assets
So it
titled?
says, so it says that the CDs, the bank accounts, the IRAs, retirements with beneficiaries. So it looks like the question looks like if everything else
Okay, if there's
is beneficiary.
beneficiaries designated on there, those will not be subject to probate. Probate is assets basically that do not have somebody like a designated beneficiary and are in individual name at the time of death. That's
Okay,
what will go through probate.
perfect. So that's with beneficiaries. And then we have a question that says, if I have a will, is probate still required?
Yes, absolutely. That probate is the process to how you would basically follow the terms of that will and distribute the assets to individuals.
Okay. We have another question, and maybe we can get a little more clarity here, but it says, where is the written tangible property note kept?
I
Maybe,
would keep it, that's a really good question, and I would definitely keep that with your documents in that fireproof box, right?
okay.
And that separate note with your date and your signature and in your own handwriting is incorporated by reference, right? But keep it with your estate planning documents and make it readily accessible to whomever is going to basically be searching your house if you were to pass away or if you became incapacitated.
Okay.
Okay.
We do have other questions here. I think one of them was about, what is the best way to leave a home to a child to avoid the most taxes and fees?
What taxes are we talking about? Because, I mean, there's
I
no
believe it's,
federal,
I believe
after,
it's capital gains. That's not specific here, but I'm assuming if the person is leaving their property to a
okay, if you
child.
leave, like I cover with capital gains, people inherit the property, they will get a step up in basis of debt on your date of death. So whatever the property is valued, whether you bought it for 100,000 and now it's worth $1 million, the person gets that step up in basis, and that 1 million becomes the new benchmark. And then anything after that 1 million that they sell the house over that amount, that's where they would have to pay capital gains.
Okay. We have some questions here. Can you place a paid car in a trust?
A what now?
A paid vehicle, a car.
You can place vehicles inside a trust. I don't recommend it, especially in Miami-Dade County, which is so Sue happy. Because
Okay.
when people see that your vehicle is titled in the name of a trust, they see green dollar signs if you
Okay.
get into an accident. So, I mean, you can talk to your attorney about that, but I don't think, practically speaking, putting vehicles inside a trust is a great idea.
Okay. We have a question here about a guarantor trustee. So it says, when the guarantor or trustee passes away and the trust is properly administered, is this a taxable event? Does every beneficiary need to pay tax?
Okay, so I went over that, at a federal level, okay, you have $13.99 million that pass tax-free, okay? So there's no federal inheritance tax if it's under 13.99 million. And then the state of Florida doesn't have an inheritance tax. So
Okay.
you're fine.
Okay, and then I have here, for someone that applied for benefits for financial assistance with the trust process, would you be able to assist the person?
So like, you mean like if they're like on Social Security supplemental benefits or Medicaid?
I believe so, because it says financial assistance. I'm assuming that's for
So
the
in those cases, if the individual is receiving an inheritance, I really suggest that you see an elder law attorney that can help you draft, that can help you have provisions in there that any money passed to that individual will be through a special needs trust so that they will not lose their governmental benefits.
Okay. We do have a few more questions I have here. They're wanting to know a little bit more about Members Trust. I know you shared some information in the beginning of our presentation in terms of the services. They're asking if it's an investment company. Do you guys do annuities, IRAs, etc.? We do have IRAs, but if you want to go ahead
We do
and
not do insurance products. We do not do annuities, okay? But Members Trust Company is a nationally chartered trust company. We do investment management and we do trust administration, okay? And we are owned by credit unions. We are the only credit union-owned trust company, that is nationally chartered. We are a cooperative of credit unions, and we were created by credit unions to serve credit union members in the estate planning and, arena.
thank you. So we are still getting a few more. I know we're past our 12 o'clock time, but I do want to share them with you if you have time.
Sure.
I have here, what happens with the home if the property was a quick claim deed to one person? However, the bank loan was not refinanced.
That you would have to take that up with your lender, okay? I mean, passing the title is one thing, okay, on the interest. But if the interest is subject to a lien, the lender has to approve for you to quickly deed that property to whomever. I mean, if there's a lender involved, the lender has to be in the know as to what has been quick claim deed, and they need to approve it.
Okay. I am getting some more about an estate. So it says here, are biological children automatically included as beneficiaries or recipients of the estate? Here's an example. It says,
Only if you die without a will,
okay,
okay?
so I have
If
a
you,
question. It says it within parentheses. It says, for example, if a mother dies during childbirth without being able to add her new child as a beneficiary, with the new child not be included, will that new child lose out on the opportunity to be a beneficiary?
It depends on how your will is basically drafted and your trust, because the trust could say any children born to me, even if
After.
not individually named.
Right.
Okay,
Oh, okay.
it
That,
depends on how that is drafted, right?
okay.
But to answer your question earlier, Cindy,
Yes.
just because you have biological children doesn't mean that they take under your inheritance. You can disinherit children, okay?
Okay.
That you can absolutely do it. If you have a will, remember, your heirs are not entitled to anything despite their sense of entitlement, okay? You make that decision, okay? You make the decision as to who is going to get your money. So long as you have cognitive ability, you can change that to your last breath, okay?
Okay.
And you just have to make provisions for it to be there. Now, the only way that they would automatically take is if you die without any kind of estate planning and a will, and then it's by statute. Okay, and then the closest relatives are the ones that take, depending on, what how the statute reads.
Right. When you were discussing the trustee, you mentioned that your own the own person would be the trustee, but somebody's asking, can you make both of your children trustees of a living will?
There is no, okay, a living will, you mean a living trust?
It says
Wills
living
and
will,
trusts,
but I'm assuming just explain that it's two different things, and so the trust is of a trust.
right. You can make your children co-trustees of your revocable trust or living trust, and you can make them co-executors of your will. But it's two different terminologies.
Perfect. Okay, I have a few more. It says here, we are getting questions about, again, what can we say to our parents about making them see the importance of creating a will and a trust? And I think having them watch this presentation. I honestly have been thinking about this, and I think there's so many people that, didn't know anything about this, family members, and I think this is a great tool. Like I said, it's going to be recorded and posted on our YouTube channel. I think it's worth a conversation if one hasn't happened. And it's very informative. So I think definitely it's having that conversation, showing them all of the examples that Tamara has shared, because all of these things can happen. So I think it's maybe watching this with your loved one and sharing it, 100%. I think it's so important. And Tamara, I think you've given such wonderful examples of all the possibilities that you yourself has seen, all the different scenarios. So I think that 100% is a way. I do have a few more questions. If you guys bear with me, it says, my home is solely under my name. I live with my partner. Is he automatically entitled to my home when I pass? And again, I think that's depending on the title you've mentioned many times already.
Now, it depends on the title and it depends on automatically, I would say no, unless the property's title and joint name. But I mean, did you make provisions in your will and your trust for them to be entitled to the property?
Okay. Another one about their home title. My home title is set up with my name as the owner and my children as it says my children as owners. Will they be owners if I pass away?
How is that titled? I mean, are you guys joint
Depends
owners
on the
with rights,
title.
full rights of survivorship?
Yes. We have other questions here. Again, for someone that applied for benefits for financial assistance through Dade Legal Services with the trust process, my mom needs help financially to assist with the trust process. She has been approved through Dade Legal Services. Would you be able to assist her? Again, we have the email here, investmentservices@edfed.org, and we can go ahead and connect you with the best person to help you out in this situation. Adult owner as REM. I'm not sure what that means. Let's see, another question. For someone that applied, so it's the same thing about the assistance. Our contact info is the investment services at edfed.org. You can definitely reach out to us and we will help put you in contact with someone who can assist. And we can provide, a phone number and a contact in that moment. Again, if it's about legal representation, members trust, Ms. Kidd has already mentioned that, they will set you up with somebody in your area. We do have a little bit more questions here. Does creation of a trust require a new checking account to be established?
No, you can retitle your accounts in the name of your trust. You need to go see your financial institutions to do that. And I highly recommend that, by the way, to put your assets in your trust once you create it and to have your, the assets retitled in the name of the trust. The only assets, once again, that you cannot add to a trust are retirement accounts because they would lose their tax deferred status. There's certain annuities that will not allow you to do that, but you can make the beneficiary designation form. You can make the trust the ultimate beneficiary. Okay.
Okay.
Same thing with
And
life insurance policies.
Okay. And I think we have one final question. I know we've gotten a lot more questions about the recording. It is going to be posted on our YouTube channel. We can definitely share a message when it's been posted. You know, we've had some really wonderful questions, so I really appreciate everybody's time. We do have one final question that I will ask. This is a little bit different. This is asking, you know, if somebody is the last living person in their family, you know, they have nobody else as a beneficiary that they're leaving anything to. They're talking about services. If something, for example, if they're putting in their will that they would like to scatter ashes, for example, who would do that? Is that a service that a member's trust can provide? And again, this is a real question, and you know, asking about this for somebody who has nobody left, or nobody who they're planning to leave this,
Okay,
you know, to do.
so members trust company will not go out and scatter the ashes, but members trust company can basically, I mean, if you leave like a funeral home, prepaid, etc., we can make all the arrangements with the funeral home for that to be done. But my suggestion would be for like a family friend or else to be the person in charge of basically scattering the ashes.
Okay. Thank you so much for answering all of our questions. Again, if you have any other questions, please feel free to email us at investmentservices@edfed.org. I hope that all of you have found this webinar beneficial. I know I have. We will be hosting an EdFed Academy webinar each quarter this year, and you can see it advertised on our social media platforms and on our website. Again, we are looking forward to hosting another webinar with Members Trust. Tamara, thank you so much. You are a wealth of knowledge. This was incredible. I think this is so informative for so many of us. Definitely a conversation starter with us and family members who really need to see the importance in this. So again, if you have any questions, please feel free to email us at investmentservices@edfed.org. We are so grateful that you have chosen to spend your Saturday with us today. And we are officially done for today. So thank you so much, Tamara. Thank you all of you for joining with us today. And we will definitely post this on our YouTube page, EdFed TV. Make sure to follow us at our social media handles at EdFedCU. And we're really grateful for your membership. I'm gonna go
Cindy, and
ahead.
I just want to put out there to please
Yes.
definitely contact EdFed, and then Michael Shuley, who is there on screen with me, he works with me, and myself, we will be more than happy to work with EdFed to make sure that, you know, your questions are answered. And, you know, and if you need help in doing the planning, you know, we can step in. So thank you very much for your time today.
Thank you. Thank you all. And I'm going to go ahead and end our session for today. And we just thank you again for joining us. Have a wonderful rest of your Saturday.
Bye-bye. Thank you.